everyone. We are going to get started with the third and final webinar of our three-part series. Today's webinar is about the role of judges, guardian ad litems, and attorneys in dependency cases with domestic violence victims. Before we start, we're going to do a little survey to get a sense of who is in the room if you haven't already introduced yourself in the chat box. So if you could look up, you can click who is with us today. Just some other housekeeping matters. On the right-hand side of your screen and materials, you will see a copy of today's presentation as well as a list of resources that we are referencing in today's presentation. At any time, if you have any questions or technical difficulties, please feel free to type into the chat box. And let's see who we have with us today. All right, social workers, visitation, we have a really great mix today. So we're going to go ahead and get started. You can go to the next. Oh no. Okay. All right. We're going to try it. Sorry, we have a little technical difficulty. We're going to fix that right now. Computers. There we go. Okay, so we're going to get started. Today, our learning objectives, we're hoping that you will leave this webinar today with an understanding about the legal frameworks surrounding child dependency cases. We hope you learn best practices for judges in cases with domestic violence, learn about reasonable efforts, the legal standard in cases, in dependency cases specifically related to domestic violence, and learn about the role of attorneys and guardian ad litems both inside and outside the courtroom, and any limitations on those roles. So with that, I am so pleased today that we have Judge Catherine Lucero from the Superior Court in Santa Clara County with us to tell us and present to us about the role of judges in dependency cases. Judge Lucero currently sits on the Juvenile Justice Court bench in Santa Clara County Superior Court. She also presides over the Juvenile Justice Dual Diagnosis Treatment Court. Previous to this role, from 2006 to 2012, Judge Lucero was the supervising judge in Juvenile Dependency Court, where she oversaw hundreds of cases involving abused and neglected children. Prior to being appointed to the bench in 2001, Judge Lucero spent her career in the area of child abuse and neglect as a prosecutor of crimes against children and the elderly, and she really specialized in child abuse and dependency cases. We are so pleased to have you today, Judge Lucero, and excited to learn more. So I'll turn it over to you.
All right, thank you. Hello, everyone. And I'm going to treat this as much as possible as a kind of almost a discussion. I'm happy to take questions. I think we have time for questions at the end. Mostly what I want you to know is that the area of reasonable efforts in the area of child welfare law is not very clear, and Judge Len Edwards has published a whole book called Reasonable Efforts, A Judicial Perspective, and you can get that, I'm sure, Google it or get it online. He actually does a state-by-state analysis of reasonable efforts. So today I'm going to be speaking from a national perspective, and I hope to have you hear the kinds of cases that I've studied, the kinds of cases that I've heard, and what we can make of that to piece together some actual bright lines. So the role of the judge, just starting out with this slide, is that Congress gave judges the authority to actually oversee the Department of Family and Children Services or social services agencies who were going in and removing children from the home because of child abuse and neglect. And that authority was actually really between 1975 and 1980, there was a series of hearings. Out of those hearings came an enhanced law previously it had been CAPTA from 1974, and the new law that came out was called the Adoptions Assistance and Child Welfare Act in 1980. And then in 1997, there was the further hearings and a new law called the Adoption and Safe Families Act. And what it really did, all of these hearings and all of this law that came about from the Congress, was it said, somebody has to oversee what's happening when children are removed from the home, and judges are the ones to do that. And so juvenile and family court judges, they carved out a role for us. And basically what we have to do is we have to make sure that when there is a state intervention, which is a huge, probably one of the most invasive state interventions in the family home, that we are making sure that the department is not only keeping children safe, but also keeping families together wherever possible. And in the context of domestic violence, the goal is still to keep children together with the non-offending parent whenever possible. So that's really something that I'd like to emphasize today. Last I was told when I was on Capitol Hill with NCJ, FCJ, Congress was spending about $48 billion in Title IV reimbursements to foster care systems. So that's a huge financial commitment by the government. So it is no wonder the government wants oversight. So the legal framework, the next slide, talks about, kind of what I just went over in a nutshell with regard to the trail of activity by Congress to empower judges and courts to oversee the removal of children. But it also, one of the things that's really important here is that reasonable effort, and the fact that if a child is removed from the home, you had to have made reasonable efforts to prevent removal. Then our goal really is to get children home as quickly as possible to the parent if the child has to be removed. And if the child can't be returned to the family, then there has to be kind of this dual track, this simultaneous effort for permanency. And that often causes a lot of confusion because at hearings, judges actually do have to find that reasonable efforts were made, and that also the department is working on a concurrent plan. And the legislature was particularly concerned about concurrent planning because of what was called foster care drift and not wanting children to drift forever in foster care. So there's this concurrent track of reunification in most cases, because there are reasons to bypass reunification, but those are few and vary from state to state. But for most cases, if the child has to be removed, then there is this dual track of getting that child home, making sure there are services to get the child home, and concurrent planning. We also have a responsibility to look even more closely at Indian children under the Indian Child Welfare Act. And that act actually requires active efforts, not just reasonable efforts. So then there are many that opine that it should be active efforts for all children, but we certainly respect and understand the reasons for ICWA and the importance of focusing on our Indian children and getting them home to their families, especially. Again, the federal law does not specifically define reasonable efforts, but there is some case law out there, and we will talk a little bit about that. And I've already mentioned that Len Edwards' book is called Reasonable Efforts, A Judicial Perspective. With regard to the next frame here, the judicial role in removal hearings, from the beginning, the judge is the gatekeeper on which children are removed. And in some cases, judges get calls in the middle of the night and requests for removals. California, that is not necessarily so. We do have a protective custody warrant protocol, and probably most jurisdictions do. But social workers are allowed to take children out of the home as long as there is a detention hearing within 48 hours. But in some states, there does need to be judicial permission even prior to that removal. So the judge really is the gatekeeper. And the judge has to make, there's two things that the judge has to decide here specifically, and is that whether the agency made reasonable efforts to prevent the need to remove the child, and would continuation in the home of the parent be contrary to the child's welfare. So already a judge in a domestic violence case needs to start looking very carefully at whether or not it's more harmful to take a child from the home or not. And that's really the balancing act that we all have in this profession is, we don't want to cause the child more harm by removing the child, but we also don't want to leave a child in a home where they're going to be harmed. So one of the things that we have to do immediately here is make sure everyone has counsel. The child should have a counsel or a GAL. Some states have both. Each parent should have counsel, especially in the domestic violence cases, because their interests are definitely going to diverge. So that's a couple of the things that the judge should be doing immediately when it gets a case in and there's any indication of domestic violence. One of the things that our court has is a domestic violence court-based agency right at the courthouse. And our Domestic Violence Intervention Collaboration, DVIC, actually has permission through standing order of the court to review all detention packets and make sure that we are not missing domestic violence. And if there is domestic violence, then the DV advocates right there at the courthouse will see and sit with the victim and start immediately right there safety planning and talking about the intervention and really urging that the potential victim to keep an open mind about what's happening. And I don't say that lightly. I mean that very sincerely, because there's often times where I know I in court have been actually told that the intervention really ultimately helped the family versus harmed, did what people might view as further victimizing the victim or harming the child. There really is a role for the advocate right there at the courthouse at the beginning. And as I said, we do have that, the Department of Family and Children Services has a contract with the DVIC, so they're right there at the courthouse. They're able to talk to the victims immediately and start to safety plan and sort out what's needed. I think I got everything there, Karen. Did I get everything in that?
Absolutely.
Okay. Then we do have somewhat of a bright line with regard to how we should be reacting as a system of child protection with the Nicholson case. And the Nicholson case was actually a class action out of New York, and the final decisions occurred in 2002. And what was found was that there was a pattern of the New York Child Welfare Department removing children from a battered woman without first trying to help her engage in services and stay safe. And so here is the holding and a case fact description. The father of one of the children assaulted her so badly she was hospitalized. Before being taken by the paramedics to the hospital, she had arranged for care. The social workers took her children while she was at the hospital and were with the babysitter, stating that she had engaged in DV in the presence of the children. And they did not allow her to see the children until after court, and they kept them in foster care for a month. And she and others sued the state over that removal, and a federal court held that the removal of the children from her violated several constitutional rights. There were several findings, and they're listed here, that they had regularly, New York Social Services had regularly alleges and indicates neglect against battered mothers, so, accusing her of failing to protect. They rarely held abusers accountable. They failed to offer adequate services before separating the children from the mother. And it is, I don't mean to be gender biased, but by and large, it is the mother of children that is the victim in these child welfare cases. They failed, again, to offer her services before separating them. They regularly separated the battered mother and children unnecessarily, and they fail to adequately train their employees regarding domestic violence, and New York Services written policies provided insufficient and inappropriate guidance to employees. So this was really a very thorough court opinion after years of litigation, and has really become somewhat of a beacon for judges and child welfare workers alike to understand that this is a whole separate approach that we have to use with domestic violence, because it's often so, as you all know, that she is doing the best that she can with the resources that she has. And something I have learned is that it's often so that she is her own expert in how to keep the children safe, and she's been thinking about that 24/7 since the day the children were born. And so we really need to understand that the victim-centered approach here and the child-centered approach, victim-centered approach is the child-centered approach, because there's all kinds of information and research that tells us that when the child is separated from the battered party, the non-offending parent, that the trauma is long-lasting and compounded, because there's already the trauma that the child has lived with, and now there's the trauma of the separation and the unknown. So that's something that I really wanted to emphasize here. So that's some pretty good, strong guidelines for how a department should behave and what a judge might look for, and how attorneys should be advocating on behalf of their clients, both their adult clients and their child clients. Examples of appropriate services prior to removal are listed here. Appropriate services include meaningful safety plans. And you know, when I first started in the business, I would have a social worker say, well, she doesn't have a safety plan, Judge, so we have to remove the children. And I would ask the social worker, well, did you offer to help her make a safety plan? And the social worker did not, because she wasn't trained. And so then we began to collaborate as a court system, and we were part of the Green Book, which was the effective interventions for child maltreatment and domestic violence. It's literally a book that's green, and it's a kind of a doctrine of 65 different approaches for a jurisdiction to adopt and tailor to their jurisdictions to collaborate with court systems, child welfare, DV advocates. We also included law enforcement, of course, social services, if I didn't say that. And so anyway, we have carved out a whole DV unit for social workers, and everybody that deals with our battered women and our families involved in family violence have training. The therapists, it's required that they have a 40-hour training, domestic violence training. I think that's fairly standard. We also partnered with the Batter intervention programs, and the training is really, really important, because you can't expect a social worker to develop a safety plan to keep children safely in the home if they don't know how. Similarly, now we've come so far because we do have the DV advocates at the courthouse. Helping the adult victim find a family member or a friend to stay with temporarily is a reasonable effort, is a service that can be offered. Giving the adult victim income, a hotel voucher, or some other amenity to help her live independently for a time while perhaps there's a possibility of having the batterer removed, or just having the batterer removed. Was that effort made? Increasing police presence around the home, enlisting the support of community entities such as churches, schools, neighborhood organizations. I've certainly had plenty of experience doing that with our very diverse population here in Santa Clara County. Providing the adult victim with legal assistance. You know, are there other legal assistance needs? Housing, immigration, sometimes even things like SSI or something related to a criminal matter or a traffic matter. Helping the adult obtain protective orders. I know that our juvenile court, when I started this work 2 decades ago, did not issue restraining orders, and the law in California has evolved, and now juvenile courts do issue their own restraining orders. But back then, and probably in some other jurisdictions, that's not available. So we really try to do the whole one-stop shop with regard to legal matters. There's also battered women's shelters, and sometimes it's necessary to call around and to help find a vacancy to see if there's space, either in a battered women's shelter or sometimes even a substance abuse treatment center, because we do have here in Santa Clara County the ability to have children under the age of 3 and the mother both go into a treatment center if that's indicated. Connecting the adult with inpatient services, I guess that's kind of what I just said, for those involving substance abuse or mental illness. And if you're like my jurisdiction, you're often not seeing isolated DV cases. It's possible, because there was a time when I saw standalone DV cases, but anymore it's usually coupled with mental health issues, substance abuse issues, poverty-related issues. They can be very complex. I've already discussed the legal assistance and the protective orders, the shelters. Securing counseling for the child is another way to make sure that children are being heard and the trauma that they're experiencing. Very effective for kids. Accessing a crisis nursery or other daycare services, providing transportation. Transportation really is a basic reasonable effort. There is case law on that. Providing interpreters. We have, I don't know, I'm sure like 25 to 50 different languages here in Santa Clara County, and I'm sure some of your jurisdictions do too. And we really do need to make sure that they have the appropriate linguistic services being offered. With regard to the judicial inquiry to remove the child, it's pretty straightforward. I'm going to be asking the department some very pointed questions about what's been done to really figure out what the next step should be. You know, how did the family come to the agency's attention? If the parent herself called, which sometimes happens, you know, or called the police, that's a lot different than if it was a neighbor or a teacher. You know, if she is calling the police for help, that's a huge sign that she's protective. So we just really need to consider that. And how does the caseworker determine that domestic violence was even an issue? Did she disclose? Did the children disclose? Was there a history, a rap sheet, something else that is indicating prior calls to the home? So you know that all goes into the thinking. And then is there a past history, and who was the perpetrator? So we need to look at that in whether or not perhaps seeking restraining orders. And then what injury had there been to the child? You know, was it physical, emotional? Is it undetermined? And we have to be really careful to understand the dynamics of family violence and their impact on children. And, you know, we could have a whole webinar on that itself. The judge must, you know, continue to ask what harm was done to the children. You have to remember the court's holding in Nicholson was that exposing a child to domestic violence cannot be considered neglectful, and instead some actual or threatened harm must be proved to remove the child. So there has to be a nexus. In Nicholson, the infant was asleep during the abuse, and her older child was at school, and mother took efforts to protect the children and get them away from harm. So courts have distinguished the Nicholson cases from cases where the child was also suffered abuse or was injured. You know, that we do have cases where mother, father are holding the child when the parent is striking out at the other parent. We've had things thrown and hit children. You know, so we've also just had this co-occurrence issue of he hits everybody in the house, and so we have injuries to the child directly on purpose, and so there's a whole dynamic here that has to be analyzed, and the court asked very directed questions to the department at this time. And then, of course, here we have to always go back to, did the agency provide reasonable efforts to remove? So secondly, the court has to address very specifically, what the agency did and how they did it. What was the alternative? One of the things I always say is, were informal services offered? And if so, what were they? If informal services were not offered, why not? Why do we have to go directly to the removal? Did the adult victim have strategies to keep the child safe? And if not, was she open to developing strategies? Or if her strategies weren't effective, how could they be further developed? Did the caseworker consult with a DV expert or an advocate? We have plenty of abilities now with the acknowledgement of the family violence issues to call on experts in some of our jurisdictions. And if that's available, then it's reasonable to request it and to require it. And that's another, certainly some of you are going to be from jurisdictions that don't have the kind of available services that we have here in Santa Clara County. But I do need to remind you that judicial leadership and leadership by probation chiefs and social worker directors are the ones that have developed these services. So it's not enough to say, well, we don't have it, so very well. We have to say, we don't have it, how do we get it? And but again, it's reasonable if you have it. It's not so reasonable if you don't have it. You can't develop things out of whole cloth in the moment, but you can plan for it long term. Did the caseworker consult with a probation or parole officer or other treatment providers involved with the perpetrator? I can't tell you how many times I saw a case where he was already convicted. He was supposed to be in his classes, and he's over at the house. He's causing problems, and nobody's contacted his probation officer. I even did a partnership at one point with a criminal court and with probation to make sure that we had a communication about what was going on and making sure that certain orders were being followed out of the criminal court. There are very creative ways that you can do some really low-cost organizing around your court systems. Many of these families are in more than one court. It's very important that if you're not sharing your restraining orders or your criminal protective orders, that you do that. Did the caseworker assess the case to determine the likelihood of future violence? And again, that would go to, lethality and training. Are your workers trained? It's very important because then we have this whole plethora of resources that we may not have if we don't look to the academia around this topic and what's available. We even have here in Santa Clara County what's called an emergency protective restraining order. So a woman can access a restraining order on the phone, which is good for up to 5 days until she physically goes into the court and gets a temporary restraining order, which is generally good for 15 days. And that's any police officer can call up 24/7 and ask the duty judge for an emergency protective restraining order. The police will usually serve them right there and do a kick-out order. Our law is also organized around being able to kick out any adult in the house who is causing physical or emotional harm to a child. And so that's called the Emergency Protective Restraining Order. And if anybody wants to see that statute or know more about that, please ask Karen to let me know, and we could certainly work out an ability to get you that information. And so again, here there's a lot to think about here and the reasonableness does go to the resources in the community, and I keep really wanting to emphasize that because I don't want anybody to think, oh my God, I have to do this and this and that, and we don't even have this and that. But now that you do know that these options exist, it's really imperative that you go back to your jurisdictions and you start creating a way to handle these cases in a much what I would consider a child-focused way that keeps the non-offending parent with the child. Then we have, this third question. The court needs to ask whether the adult victim was offered the assistance to keep herself and her child safe together. And this is kind of just a distillation of what we've been talking about, because really that needs to be, if it's not safe for the child in the home, it's probably not safe for her either. And a safe non-offending parent is a safe child, and vice versa. It's really, we can't really just pull the child out of this equation, because the child is going to need to be with the non-offending parent, and if they're not with them, they need to see them frequently. And this will minimize the trauma to the child, because we have the initial trauma, which is being in the violent home, and then we have the secondary trauma, or it's not even secondary because it's actually can be more significant than the first trauma. We have the trauma of separation. We have an excellent research department out here at Stanford University, and there's a doctor, and his name is Victor Carrion. He's done a lot of research on trauma and separation and loss. And a child, when they're separated from their parent, they actually believe that they actually believe they may not survive. I mean, it is severe. It is life-threatening. And so it's very important to make sure that that's a very last resort. So if we can keep her safe with the child, that's really our first order of business. And I'm going to want to know that. Why wasn't that done? If it wasn't done, I really need to know the details. And also, it's very common for the batterer to completely isolate the victim and burn the bridges for her and her family and her sisters and her community. But you're just going to have to understand that it's time, and we don't have a lot of time, but over time, victim-centered services do allow people to open up and to be open to reconnection. It's that whole seeking safety model. Once people become safe, then they are able to reconnect. And that's also another really great model to use with our domestic violence victims, is the seeking safety model. So this question does go to the heart of the reasonable efforts inquiry, and it's very important that the judge take the time to understand, if the parent and the child cannot stay together, what would it take? What would it take to get them back together as soon as possible? One of the mantras that we developed from the Green Book years, which we did spend years from about the year 2000 to the year, 2000 and almost 2010, working in the Green Book realm, is that we said, let's remove the batterer, not the children. So that's somewhat of a paradigm shift for some people, but not all of us. And maybe I'm showing my age, and you're all thinking, oh, that's yesterday's business. But we really do need to look particularly at how we can get him to leave the family home. The court should pay particular attention to the language of the petition. Does it hold the batterer accountable for his violence, or is it conclusory and blaming of the victim and talking about engaging? I mean, nobody engages in domestic violence. So, ask your county councils to really look at your petition language and begin to evaluate the power of the words that are in that petition and what the blaming is, making sure it's on the right party. And the court should determine whether the agency sought to remove the batterer from the home, even through voluntary agreements, or using the power, of course, of the other courts, family court, or, where else can you get a restraining order? If there is a fit parent, then we don't even belong in this child's life. If the mom can safely protect this child with restraining orders and other safety planning, then truly we need to be finding an unfit parent to take jurisdiction. So in summary, the role of the judiciary is to ensure that the cases are properly screened for domestic violence, and I've indicated ways that we do that here. We do have the domestic violence-based court agency looking at our detention packets, interviewing folks as soon as they come in the front door. We have our specialized unit that takes our complex cases for domestic violence after they're screened. We ask social services about the harm alleged to the child, and not just some narrative about domestic violence, but we want it linked to the harm. We ask social services about what services were provided, whether or not they assessed the non-offending parent's capacity to be protective, why the child can't be kept with the mom. And we also want to ensure that victims feel safe in court. So anything that we have to do to make that space safe, whether it's making sure that The seating is very separate, making sure that folks with restraining orders in place aren't talking with one another. I've even had to make it so that the victim couldn't see him while he was glaring at her in the courtroom. Making sure everybody's on their best behavior, of course, is important. Making sure that she's escorted to her vehicle after the hearing if she is afraid. This is a very real occurrence. This is a very real event and a very real series of events. So we really want to honor that by treating victims well in the courthouse. If she was in criminal court on all fours, she would be a victim, and she would be treated with victim advocates and parking, reimbursements, and we have to remember that she is still a victim even though it's dependency court. Of course, always ensuring party representation. If something wasn't done, instead of, for me, finding no reasonable efforts, because a no reasonable efforts finding will result in no funding to the Department of Social Services for that case, I'll put it over for 24 hours and invite the social worker to do some safety planning or to look for housing or to get a restraining order. There's different ways you can handle this. Also, the role of the judiciary is to review case plans. And if we do have a removal, then we want to ensure that they're appropriate for domestic violence cases. We want to make sure that we are reviewing the placement of the children. Are the children safe where they are? Sometimes children end up in other violent homes. We have to make sure that our foster parents, both relative and non-relative, and NRFMs are violence-free homes. So we review placements. We make sure that everybody's checked out and that the children are in safe homes. We review we review and discuss visitation, even with the batterer, because unless there's a finding of detriment that visitation would be detrimental, the law requires, as part of reunification efforts, to have visitation for both parents. Obviously, ensuring the visitation is safe and that the people supervising the visitation are trained in domestic violence. And it's not just some, random place that doesn't really oversee things. And then we also want to constantly question whether it's safe to return the child to the home if the child has to be removed. Now, families come in all shapes and sizes. They come from all cultural backgrounds and traditions. There are many, many reasons that victims stay with a perpetrator, that husband and wife stay married, that long-term relationships stay together. That really isn't for me to decide, and social services has really, I think there's been some negative legal repercussions for social workers who say you have to leave him or else. So we don't do that, and that's not even a respectful way to handle a person. So it's good that we don't do that, because I know we used to. But there are two scenarios. One is where she says where she intends to leave, but there are barriers, and there's the couples who want to stay together. With regard to the barriers, we have housing barriers, finance barriers, we have language and immigration. So we really want to be prepared to address those barriers, whether it's a U visa or a VAWA, or trying to get a voucher, a housing voucher. We really want to begin to assist so that if she has chosen to end their relationship, that can be something that sticks. Because if it becomes too difficult, and I know that you were able to watch Rachel's story earlier in the series for some of you, then you are certainly seeing that the tendency to want to go back is going to be there. And it's not going to be for any other reason but pure survival. If she opts to remain with the perpetrator, we have to remember to be respectful and give the dignity of that family, for that family's choice, to them. But we have to create a safe environment within the home for her and her child. And sometimes that requires separate counseling. Certainly here in California, if there is a 52-week batterer treatment program ordered, then there cannot be any couples counseling. But we do have a program called La Familia, which addresses the Latino culture and traditions. they don't do couples counseling. They do family nights and family gatherings and things like that, because we have to be respectful of tradition and culture and all the reasons why a party may decide to stay. People don't want to live this way, but they also don't want to give up the only life they know either in the positive things. I have this really strong belief that when we don't let people sort it out and kind of try to develop a new approach to their family system, that all we do is we push everything underground, and they're just waiting for us to get out of their lives, and they never learn to be together in the healing. I think there's a lot of value in trying to work with a family. I have returned children to families where we had originally separated for domestic violence after he finished his programming and she finished her programming, which usually involved a DV support group and counseling and, if necessary, mental health or drug treatment. And I always ask for the Plan B, and I ask for the whole family to be involved in the Plan B. What will happen if things go backwards? Grandmother will come over and get the child, because I don't want that kid going back into foster care, because it's just too difficult for the child. But I want the family, and in the old days, families did have plans. I want the family to make a plan. And I'm not saying that we'll never again be in that family if necessary. I'm just saying families sometimes can handle with a Plan B, and especially when the children are getting older. One of the Green Book strengths, I thought, was the respecting culture and community component, where we went to community. We talked with the Ethiopian community. We talked with the Latino community, the African community, and we really got some good understanding of why folks may have the traditions that they have and the cultures that they have. I myself come from a very traditional culture that you stay married no matter what, and there's some very real value to that if people can be safe and people can change their behavior and people can stop drinking, blah, blah, blah. Examples of victim services is next up on your slide. And how am I doing on time, Karen?
You maybe 20 more minutes, 15.
Oh, okay. So I'm probably almost done here. So we have examples of victim services that we have developed here. Victim support groups, and the victim support groups are led by the same group of people who are at the courthouse on day one, the domestic violence intervention collaboration, and they have one-on-one, and they have victim support and victim advocacy. So their whole goal is to, help eliminate barriers, to help with the social worker with any case planning, provide therapy, both group and individual. We've made a lot of efforts to, be very creative in our courts. One of our courts is called Family Wellness. And at one point, we even were able to secure 100 Section 8 housing vouchers and start housing people. We're always really in the know and have up-to-the-minute information about where our shelter beds are and how long a wait might be. So it requires a lot of expertise, but your team can become an expert in this area. It's not difficult. It just takes the energy and the intent. We look at, we have what's called an eligibility worker in the court, making sure that folks are connected to all the kinds of public assistance that they can possibly be connected to, and that they're making their appointments, and if they're missing their appointments, what they can do to get back on track. We have employment opportunities, educational opportunities. It's, you name it, she's very likely, and he's very likely to need other services, and so it's very important that we become well-versed on this. But with regard to victims, we also have transitional living services. The visitation center has a step-down model where after a certain amount of time, there's an automatic step-down to, perhaps we start with one form of visitation and then we step down to the next. And we're very committed to making sure that non-offending parents who are, if they're not living with their children for other reasons, are attending medical appointments or school meetings, that kind of thing. And then, of course, we have the legal assistance, which I already discussed. In reviewing the victim's case plan, again, we assess reasonable efforts. We need to make sure that services are available and accessible. When I first started Family Wellness Court, we had a 4 to 6 month wait for alcohol and drug treatment. And in California, it's called a fast track. So if your child's under 3, if you haven't significantly ameliorated the conditions that brought you into court, you are looking at no more services after 6 months. So I felt that having a 4 to 6 month wait list on a treatment slot was unacceptable. So we were able to cut that down to, I think it's 30 days, but they are assessed within a week. We actually have in-court assessors as well. In our dependency court, we have drug and alcohol assessors, we have the DV advocates, we have the eligibility worker, and in some cases, we do collaborate with the adult drug court judge. We even have access to a psychiatrist and to somebody who does SSI applications. So, you know, we need to make sure services are mandated, that they're accessible, available, and provided by those with the expertise, especially with the trauma piece and the DV piece. It's tied, the service, to an identified need. It's safe, it's useful, it's culturally and linguistically appropriate, and it recognizes the impact of trauma on the victim who is participating, who we want to have the ability to participate in the case plan. You know, transportation is always a big issue, you know, where people live and where we expect them to go. You know, we have some pretty high expectations for folks who are the least resourced in our communities, sometimes the least educated, the most afraid. So we really need to make sure that we recognize the trauma-informed courtroom recognizes that everybody in that family likely suffered traumatic injuries, either emotional, mental, physical, and we approach it that way. You know, the parents, the child. Sometimes it's generational, you know, and I guess I'm just asking for that compassionate lens. You know, I still have to make the tough decisions, but I can do that with the compassion that's required for dealing with such a fragile population and for dealing with our young children and wanting to make sure they stay safe. With regard to substance abuse in cases involving DV, of course, there are special considerations. Sometimes the batterer has a pattern of sabotaging recovery efforts, and that can be very subtle. I had one gentleman who would steal her teeth. She had a full set of false teeth, and when it came time for her to go to her different services, he would steal them, and she didn't want to leave the house. So there's all kinds of sabotaging that occurs, you know, that we wouldn't necessarily think is DV, but it is. That's, of course, such a cruel thing to do. Does he supply the drugs or threaten to leave or threaten her if she refuses to take drugs? Is the batterer more violent or lethal when he's using or not using? And there's a whole, you know, discussion on that as well. But that's a point to consider. And are you aware of any of the probation or parole requirements around this that complement your case? And that could be for both parties. You know, sometimes we've had people drug testing for 3 entities. We've had them drug testing for us, for a drug treatment facility, and for a probation officer. And that costs the county a lot of money. I think we did an analysis, and each agency was spending $500,000 a year on their drug testing contracts, and nobody was sharing the information. And we had spent a lot of time with a lot of people, you know how it is with government, trying to figure out how to share this information. So not only did we not have to spend $1.5 million on a contract, you know, we could just have one contract, but so that we could treat people more humanely and not make them be watched peeing for 3 times in 1 week. Then we go to the perpetrator's case plan. In many child welfare cases, perpetrators are invisible. You know, they're not interviewed, they're not engaged, they're not made parties to the case. They're just invisible. And as you know, that means that the whole paternal side of the family is not looked to. And it's, that is the law, is that we look at the paternal side of the family as well. The perpetrator should be identified, the father of the child, if they are in the case. Obviously, if the perpetrator is not the father of the child, then I don't have jurisdiction. Although I have made orders that I won't return a child to a couple unless the father of the non-father also participated in services, and I've been able to get people involved that way. But paternal, finding who the father is, and if that father is the perpetrator, making sure that they're held accountable on the safety plan, focusing on safety, focusing on accountability. I have found some of the best customers, and we do call them customers, have been our fathers who have gone ahead and rehabilitated, gone through their drug treatment, gone through their 52-week programs. We now have them back as mentors for other fathers. And there's a lot of stepping up that can be done by fathers if we include them. And of course, we know that having two parents is good for children if those parents are safe. Examples of services for the perpetrator are the BIP programs, the Batter Intervention programs, visitation center services, which not only observe visits but maybe coach. They need substance abuse and mental health services as well. Parenting classes. We have a Parenting Without Violence course and a fatherhood course that focuses on the importance of fathers and focuses on the importance of nonviolence. Again, we want to be in contact with their probation and parole officers. We want to offer the appropriate services. I once had a Punjabi gentleman who needed his DV class in Punjab, and we were able to arrange that, and he could not be more grateful to me and to our court and to our social workers for arranging that, because he felt that he really needed to learn what he learned, and we offered it in his language. And it's really a beautiful thing when people can get help and take it in, and it's made a difference. Again, there's the housing services. We had 8 houses for our ladies in our family wellness court, and we actually turned 2 of them into father-child houses, and they were outstanding. Fathers need housing too, even fathers who are batterers but who are compliant and who are clean and sober. Employment services. We have relationships with unions. We have, our dependency court hallway is full of what I would call kind of like it's a community bulletin board kind of resource. I have resources for medical and jobs and vision and child care. And so whenever everybody always gets all these flyers and everything, I just go put them out there, and we just have really developed some good connections for our fathers, for our mothers. But I really would emphasize the mentor fathers, because they get rehabilitated and they want to give back, and we've made a way for that to happen through mental health money, through drug and alcohol money, and through our board of supervisors who are funding these positions. Case plans for children, looking at immediate safety needs of the child. Those should obviously be addressed as well. It should include a safety plan and counseling targeted to any harm suffered as a result of the violence in the home. Visitation should occur with both parents unless there's a finding of detriment. Siblings should be kept together at all costs. It's not acceptable for me in this county, and I do often order that siblings are not to be separated, that a child should lose their parents and their siblings all in one fell swoop. So we keep children together, siblings together whenever possible. Now sometimes there's a compromise and we have to send them out of county because it costs so much to live in this county that some of the foster homes that take more than one child at a time are not in county, so we do sacrifice something there. But I think it's really important for us to be aware of how important it is for our siblings to stay together if they're safe with one another. I mean, there's exceptions. There's older children not safe with younger children, that kind of thing. But if they can be kept safely together, they should be. We have support groups for kids with other kids that are going through the same thing, as I've already explained. We need to determine if relatives are safe. Should we place with the relative, the non-relative family member? We don't want to re-traumatize children. They've already suffered the trauma of the violent home and then the trauma of separation. And the resiliency, we can't count on much past that. So that's another reason to keep kids together in their sibling groups. And then kids should be in court. Nothing about us without us is the mantra of the Kids Connection, which is a group of former foster youth here in California who have had a major impact on changing the law around children in foster care. Nothing about us without us. LA has a standing order. Every child comes to court, even the infants, because it does make a huge difference for judges and for social workers and for all of us to see kids in court. It's a whole different hearing when we see those children and we realize that we're dealing not with a case number, but with a little one. With regard to post-dispo hearing, so that's after jurisdiction, I've already talked about the fast-track cases. Here in Santa Clara County, after we do the disposition, we have a 45-day case plan review. That is not by statute. That is by best practice. We want to make sure that the social worker has hooked the family up with all the services that I have just ordered. A written referral and a phone number is not enough. I'm looking for warm handoffs. I'm looking for follow-up. I'm looking for any indication that this person was helped to the service, that this person was helped making connections to a service. We also have parent partners here at the Social Services Agency. They have hired, paraprofessionals, people, just ordinary people from the community to come and help parents access services. And so we need to make sure we're tracking that, because you don't want to come up on a 6-month statutory hearing and nothing's been done. And everybody has a reason why, and you're not really sure what happened. So it's a safeguard for both the department and for the parent. And, having a 90-day review to consider return, there's nothing wrong with having a review and seeing, where people are at and what needs to be done if we haven't quite got it right yet. We need to get, of course, for the review hearings, we need to make sure that there's mental health in place, DV advocates, the support groups, the treatment, and the assessments. Sometimes we do DV assessments. They're formal assessments with the couple if we're not quite sure what's going on with the dynamics. We also do assessments of infants and toddlers with our First 5 collaboration with the it's a government commission that focuses on the first 5 years, and they do some outstanding assessments to make sure that kids are on track, even pre-verbal on track. And then we're looking for concurrent homes, and again, here's the visitation. We're looking to make sure visits are being done, that they're being stepped down if appropriate, that they're being if there are still problems, that we look at better supervision. Maybe we're looking at having the visit where the child lives versus at a third-party location. And then the permanency hearings. And those are after services have been terminated, of course. But prior to that, we're always looking at the reasonable efforts, and we're always looking to reunify the family. But at the 2-1 hearing, before I terminate services, I'm looking back over the record, and I'm examining for the efforts, and I'm examining to make sure we gave this parent every chance to get on a better track. And I think that this is helpful because it helps us sort out, instead of prolonged permanency planning. If somebody's been given really good efforts to heal and to live differently, then we really need to move on if they haven't been able to take that up. So, of course, at permanency hearings, then we're looking at making sure that the child's in a permanent plan. It's that concurrent planning that's paying off here. We should make sure there continues to be visitation and contact unless we have finalized an adoption. But here we do also have a practice of post-adoptive contracts, mediation that involves an adoptive parent if they volunteer to look at how to maintain contact after the adoption. Sometimes it's just a P.O. box and a picture once a year, and sometimes it's more than that. But we have to recognize that a child will look eventually for their parent. That's my experience. The court should also ask if the child's caregivers are committed to continue child participation in services like counseling and trauma services after cases are dismissed. And we want to make sure that everybody that we place children with have also been screened for DV, because we don't want to expose them to any violence in their new environment. And if we have teenagers, we want to make sure that they're well aware of healthy relationships and reproductive health. And we don't want to encourage cycles. We want to end cycles. We want to break cycles. And this is a really opportune time to do that. So we don't want to just place kids with families that are living in violence or are not paying attention to the fact that this young woman or this young man really needs a little bit of extra information about staying safe and in healthy relationships. That's all I have. Thank you.
Thank you so much, Judge Lucero. That was a really wonderful presentation. My name is Karen Zavora, and I'm going to be presenting to you today about the role of attorneys and guardian ad litems in cases involving domestic violence. Just a short bit about my background. I've been in practice for about 10 years. I've worked primarily in legal aid organizations and spent 3 years as a child advocacy attorney here in Reno, Nevada. And I'm also, in addition to working with the council, I'm also the directing attorney of the Senior Law Project here in Reno, where I work with elder abuse, exploitation, housing issues, lots of civil poverty law. So that's my background, and with that, I'm just going to jump right in. If you have questions for Judge Lucero, you can type them into the chat box, and if she has time and is still here, she can certainly try to answer some of them for you while you're listening to my presentation. To start with the role of the attorney and guardian ad litem in the courtroom, for the attorney, your role really is to advocate for your client's wishes or their position and protect their legal rights. So you are their voice in the courtroom. You are the one that will primarily speak for them and present their case. And that's an important role. And you're also taxed with making sure that the court system is following the rules. So it's a huge role. One important thing to note is that some attorneys and guardian ad litems may take a best interest approach. So instead of advocating for your client's expressed wishes or position, you are required to sort of report to the court about what is in the child's best interest. And it's an important difference to note and know about whether that attorney or guardian ad litem, what position are they supposed to be taking when they're in the courtroom. If appropriate, one of the main duties of an attorney would be to argue about whether the agency has provided reasonable efforts. We know from studies that judges are sometimes reluctant to make that finding on their own or reluctant to make a finding of no reasonable efforts, even if there is an argument, and for good reason. It has implications for the agency and funding and things like that, but it's still a really important tool in the lawyer's tool belt. Even though, in my experience, judges may not make the actual finding of no reasonable efforts, they're often willing to threaten that finding unless the agency makes changes in their case plan or treatment of a case. And so it's not something you want to bring out of your tool belt all the time, but it's an important tool that attorneys specifically can use. One thing Judge Lucero mentioned at the beginning is that we really have a federal law here, and reasonable efforts are not defined by that federal law, and they may not be defined well in your state's statute or case law in your state, but other states have good case law and statutory language about domestic violence. And so I did that often in my practice as a child advocacy attorney, where I turned to another state for an analogy to support my argument and to help the judge see how, in a domestic violence case, or any other case for that matter, maybe a reasonable effort should be something different. Another large role for the attorney is to help keep the client comfortable and prepare them for the courtroom experience and process. As a child advocacy attorney, that was a huge role, is to make sure that these children felt safe, comfortable in the courtroom. I wanted, just like Judge Lucero, I wanted my clients to be there if they felt comfortable and it wasn't going to be harmful for them. And in fact, our court also had a requirement that you bring children to court unless there was a motion filed with reasons why, and sometimes it wasn't appropriate, and we had therapists saying it could be harmful to them. But for the victim, for the child, even for the perpetrator, you need to prepare them for the courtroom. Judge Lucero talked about that there are sometimes special waiting areas where you can have your victim on how the child will participate, that they would go first or last or anything to make the courtroom process safe, because this is a really intimate court process if services aren't being provided or you're really on a different page than the agency. It's important to ask for another hearing, and most jurisdictions will allow you to request an intermediate hearing in between the statutory hearings. So that's a really important tool, and it's important for people that aren't attorneys to know that, to maybe request that of the attorneys that they are working with. A huge part of the advocacy of an attorney, in my opinion, is outside the courtroom. And I want to say this knowing that there are many attorneys and guardian litems that have huge caseloads. I was fortunate to work with an organization that followed the American Bar Association's recommendations for child advocacy attorneys and caseloads, which I have linked to in the resource list. So I was really able to have a relationship with my clients, attend the meetings I wanted to attend, and really advocate for them outside of the courtroom. And I found that advocacy was game-changing advocacy. So when you're advocating for your client outside of the courtroom, I think the first and most important thing is to really know what your client wants. If you're representing the victim, does the victim want to stay with the perpetrator, leave? This needs to be a realistic discussion and an honest discussion, because if you advocate and create case plans and push for things with social services that involve your client leaving the perpetrator, but really she wants to stay, you're not doing you're slowing down the case process, and you're not helping it out. So in order to really know what your client wants, you need to develop, or you hopefully will be able to develop that relationship with your client, which I think is extra important in domestic violence cases, where there can be trust issues as a barrier and other things. So especially with children as clients, I really took the time to go to their homes and sit down with them, and depending on the age, I would play with a child and really let them know that I am someone that they can trust, and that I really am on their team. The one thing I did a lot of is attend the child and family team meetings. Again, if you have a huge caseload, this might be out of your ability as an attorney, but a lot happened at those meetings that changed the course of the case. The next thing you want to do is really educate yourself, importantly yourself and others, about domestic violence. You cannot be an effective advocate, in my opinion, if you don't really know about domestic violence. And I really say this from experience. Earlier in my career, my education about domestic violence wasn't that great, and I held on to many of the myths that Jennifer Rose talked about in our first webinar. I didn't understand why mothers weren't following case plans. I didn't know about the impact of trauma or how they were really actually protecting their children from violence while in the home. And that impacted my advocacy. And so I think anyone that's going to work in this realm really needs to get a training about domestic violence so they understand what is really happening in those cases and can get rid of some of the judgment. If an attorney or guardian ad litem can only do one thing, it would be to attend the case plan meeting. Our social services allowed, unless the parent objected, all participants to attend their case plan meeting. Definitely, you should be able to attend the case plan meeting of the person that you're representing. This is really where the services are developed with the agency. And this is a time after knowing about what services are appropriate for domestic violence that you can object or, argue against a service that's not appropriate, or on the next one down, if there are barriers to it. So if the agency is asking your client to do a parenting class that takes a 2-hour bus ride to get to, maybe that's not the effective thing on the case plan. And sometimes there's a tendency to throw in the entire kitchen sink into the case plan and have lots of things, and you really can push in that meeting to really narrow the plan to those things that are going to address the reasons that the child was removed. Another great thing is, and a really vital thing in my practice, was to check in with my client and the agency and all the other players, the attorneys, therapists, in between hearings, to make sure that the agency is providing services and addressing barriers, and to also make sure that my client is able to follow through. And so I want to know early in the case that my client missed a therapy appointment, and I want to know why and how I can help her not miss the next one. I don't want to wait until a week before the hearing to learn that there were missed appointments or the referral didn't go through. I really want to know as soon as possible. And again, I know caseloads are large in these cases. Some attorneys' offices employ their own social workers that can help with this, but it is such an amazing tool to advocate outside of the courtroom and know what's going on in your cases as much as possible. And especially with children, if you have children as clients, I thought it was so vital to visit those children and connect with them in between those hearings, so they knew that I was there to advocate for them, because a lot of the problems come up in the details. You might have a perfect case plan, and then 3 weeks later there's a big barrier or bump in the road, or something has changed in the case. The other thing I would add is that nothing prevents the victim from getting other services. So if you know of an advocate, if you know of support groups out there, it's okay to connect your client, whether it be the adult or the child, with other services that you know about, if you think that's going to help and if they're interested in doing those services. And then finally, the advocacy outside of the courtroom. One of the things that Judge Lucero mentioned is that not every jurisdiction has all of these services. I've worked in Reno, which is a metropolitan area, and I've always also worked in rural Nevada, and the differences in services are very apparent. But that doesn't mean that you still can't adopt some of the principles involved in domestic violence cases, and couples counsel, not do couples counseling, and really follow this process even though you don't have those services. So you can work either to find those or to do the best that you can in that jurisdiction. The other thing that gets interesting as an attorney or guardian ad litem is sort of the ethical considerations in the case. The first one is you really want to know what your role is and who you are advocating for. Again, an attorney is generally charged in these cases to advocate and represent their client. A guardian ad litem or a CASA, for example, may be charged to report on the best interests of the child or the family. So you need to know your standard before you get in to talking to people. And I think that it's really, really important that you explain your role and the rules to your client. And if you're a guardian ad litem, that you explain your role to anyone you're talking to. So especially with children, if a child often has an attorney and a CASA, And those can be confusing to the child about confidentiality and what they can say. I've had child clients be really upset when they saw something in a CASA report that they didn't think would go there because they thought maybe it was confidential. And so an attorney has confidentiality and maybe not a CASA to the same extent. So explain your role to the person that you're dealing with so they know how to interact with you and there's not a breach of trust. With that, there are lots of rules surrounding and lots of occasion for you to have to think about these rules in these cases about mandatory reporting, safety and confidentiality of your discussions with your client. In Nevada, for a while, we had perplexing rules which were contradictory, where we had a child abuse and neglect statute saying attorneys were mandated reporters, which conflicted with our rules of professional conduct, which did not allow us to reveal anything without the permission of a client unless it rose to the level of substantial bodily harm. And so they've changed that now and clarified things, but we really were in a tricky situation where you might have information to believe that a child was harmed during the last visit or is scared of being harmed, or a mother isn't safe, or if you're representing the batterer, that they are intending to do something unsafe. And so you really need to know, these are important ethical rules to know and really know the minutia and the details. And I would say that as an attorney, one of the greatest things you can use is to call that hotline at your state bar association to ask for help. There's often, most states have a hotline for attorneys to call to ask, hypothetically, what can I do in this situation? Is it appropriate for me to reveal this information? And once you figure that out, it's important to express that to the client. So I always talk to my children clients about confidentiality and about the limits of that confidentiality. If they are going to express to me that they're going to harm themselves or another person to such a level that I believed that they were at risk for bodily harm, then I would have to reveal that under my rules of professional conduct. And these issues arise often. I had lots of children reveal things to me in the course of my representation, some that were reportable under my rules and some that weren't. And sometimes that conflicts, that your rules of professional conduct can conflict with your own moral compass. And so it's just important to know those rules. And remember that you can't present false information to a judicial officer, and you can't make arguments to the court that aren't in good faith. So with children clients, for example, I made sure they knew that I would always present their wishes in their voice. And I would say to them, if you told me you wanted to live on the moon, I would always make sure the judge knew that. But I couldn't really argue that because there's no basis for it. So making sure your client knows that role. The other thing that comes up a lot in advocacy and family matters is conflicts of interest, especially when representing children, but also in other scenarios. It can be a conflict between two clients' wishes if you're representing a sibling group. It can also be a conflict between what your moral compass says and what your client is wanting. If you're representing, for example, a perpetrator and they're really pushing for one thing that you know might be harmful to the children, you're in a pickle. And so your job in that scenario is to really figure out your rules and inform your client of those. The last thing I would say is, again, to challenge your own assumptions about domestic violence. So really make sure that you aren't advocating for a position or making an argument based on your assumptions. If you think she should have left, for example, and so you're not standing up there and giving it all you've got because you're judging the client. And that happens, and it's really important to get those things out of the way so you can really effectively represent your client. Clients often get appointed counsel, not private counsel. So they didn't choose you. They didn't choose your representation or your judgments or your assumptions, and so it's important to get those out of the way. And I'm saying the word important a lot because it really is all very important. And then the final thing I really wanted to touch today is I know that we have social workers and visitation center people and domestic violence advocates in the room today. And I would just say that attorneys and guardian ad litems, unlike social workers, do not generally get mandatory training about domestic violence. And they are sort of a part of the court system that sometimes gets forgotten about. And like I said, those myths and assumptions about domestic violence affect the attorney's ability to advocate for their client, to push the bounds of reasonable efforts in their jurisdiction, and to really make sure that appropriate services are being given. And at the end of the day, all of that hurts children because we know that children often do better with their families. And if we're not giving them the right services, if we're not making the appropriate arguments because of our lack of education about domestic violence, we're really, in the end of the day, hurting kids and families. So for those of you out there that aren't attorneys, please connect with those attorneys in your jurisdiction, the child's attorneys, the parents' attorneys, the attorneys for your agency. Connect with them and ask them, have you ever had a training about domestic violence? And if not, offer to give a free one. It's going to affect the practice in your community. I think that's all I had today, and I would like to open it up since we have about 9 minutes left. I'd like to open it up to questions. If you have questions for myself or Judge Lucero, please feel free to type them into the box, and we can answer. Just waiting for okay. From Shelley, what information can a supervised visitation center give to a guardian ad litem? That's a great question, Shelley. I'll take a stab at it and then turn it over to Judge Lucero. What is safe visitation? How to make visitation safe? And domestic violence, just the principles of domestic violence. Judge Lucero?
Okay, okay, so I guess I would start with what information can a supervised visitation center give to a GAL? Well, a GAL is generally a court-appointed agent. So if it seems to me that that person would have a right to information from a supervised visitation center about how their client fared, how the visit went. If there is problems gaining that information, you may want to ask the court to either create an MOU or a court order to facilitate that. Now the supervised visitation center might have its own rules and its own obstacles, so it really does require a conversation with that center. But I think in the main, an attorney who's representing a child would have the right to that information. And then I'm curious to know more about what was involved in creating an agreement with local courts to have DV advocates available in initial hearings for safety planning. That's from Shannon Reed. And basically, we partnered with DV advocates who are community-based, and DFCS, our social services agency, we made aware that we needed advocates at the courthouse. I tell you, this didn't happen easily because community advocates felt they would sell out if they became kind of co-opted by our systems. But I think a great respect has grown for this group of women that kind of came and rose to the occasion and said, we'll take this contract, because DFCS, our SSA social services people, actually did an RFP and pays this group of women who created the DVIC to specifically be courthouse-based and be at the courthouse and then provide the closed DV support groups, the individual therapy. So that's how that was created, people sitting down and talking about what they needed and then finding a funding stream.
And then we have from Deborah, what is the best way for a DV advocate to approach attorneys, guardian ad litems to offer training? For guardian ad litems who are either they're court appointed, they could be attorneys, they could be fulfilling a CASA role. Most CASAs and guardian ad litems have to go through some sort of training to become to be in that role. So my suggestion would be to see if you could, during that initial training, by approaching the CASA organization or approaching the court who's appointing guardian ad litems, to see as a part of that initial training, could you provide an hour or so on domestic violence before they start getting the assignments. For attorneys, I think the biggest carrot for attorneys are continuing legal education credits that we need every year. And offering CLEs, you can coordinate with your state bar association. You can coordinate through social services, and you get approved for CLE credits, and attorneys will come for that. And I will say, as an attorney in this area, not many trainings came through that were specific to this area of practice. And so having one of those in your local jurisdiction that is approved for CLE credit, I think would be really attractive to attorneys who would like to not sit through, an estate planning clinic, but would rather learn something about in their area of practice. Then we have a question from Jesse. I have had issues obtaining information from caseworkers as a CASA without filling out paperwork. However, they expect us to give the information freely. Why is that? Judge Lucero?
Yeah, well, I think that, again, is a communication issue because your judge should be making it clear to the caseworkers that CASAs have a right to the information. In fact, they need the information to write their reports. So you're well within your, within your reasonableness to make a request, and then if that is not being honored, to go to the court, because I'm the one that swears the CASA in and, has developed with the CASA director the CASA program. And if there's a protocol that needs to be shored up or a reminder that has to be given, then that needs to be done. And you have to remember, a lot of these things we're talking about have they've been around for a while, and there's changeover and turnover and philosophical changes and the wind changes, and you really do need to just keep an open mind, and you have a right to that information, and if it's not happening, I think you go to the court and tell the court you're having trouble getting that information.
And I would add, Jesse, in my jurisdiction, we get orders of appointment. And those orders include information that we can show third parties about the information we're permitted to receive. We revised those orders after experiencing some difficulty getting information about our clients, and so that may be something that your CASA supervisor can look at. Is there a problem with the language in your order of appointment, either as a CASA or as an attorney for the child or parent, that is impacting your ability to get information? Amy asks, can you speak more to batterer intervention programs? What do they entail, and who is providing these services in your area?
California has a law that speaks to this issue specifically. It's a 52-week batterer intervention program law that after a certain type of conviction in a criminal court, the batterer must be sentenced to the 52-week batterers intervention program. There is a whole system of accountability largely run through our district attorney's offices. The curriculum is standard. The reporting out is standard. And who provides it? It's basically, folks who come and say they want to do it, and then the DA certifies them if they are certifiable to run the programming. So it is all in statute. And it looks like the statute was developed here in California see, I'm not finding the date, but you could just Google California Batterer Intervention Programs and you would see the whole statutory scheme and framework. So it's very, you know, prescribed, and it's not left to chance. And so I hope that answers your question.
And I just, to add to that, Amy, I have the last slide in our presentation up. So the National Council of Juvenile and Family Court Judges houses the Resource Center on Domestic Violence, Child Protection, and Custody, and we provide technical assistance to professionals and to victims on issues of child protection and custody cases that involve domestic violence. And so as a professional, you can email us, you can call our 800 line, and we can find for you answers to these questions. And so for any of those participating today, as a professional, I wish I knew this resource existed. We have state law charts to help you, you know, argue in court. We have all sorts of things, and we have individualized and tailored assistance. So feel free to put in a request to our organization and about, for example, batterer intervention programs, and we can get you some resources. And we've gone over time, so I'm just going to take one last question. Joe is asking, what is the best way to educate the court during the case on child welfare best practices for domestic violence?
Well, judges love case law, so that is a respectful way to educate a court during a case. So you can look to your own statutes, your own case law, and again, Judge Edwards' book would have the state-by-state analysis for you, very recent. I would then seek to perhaps meet with the judge separately, not certainly during the pending of the case and not about the case, but you know, maybe with a collaborative. I don't know if you have the ability to have a systems meeting or start a systems meeting or take the judge to lunch with a defense attorney and a prosecuting attorney, or you know, a social worker counsel and a child's attorney and a parent's attorney, and kind of have a discussion and maybe even offer to bring NCJ, FCJ into your jurisdiction for training. There's also free judicial training at the Institute. The National Council does a free DV training that's excellent. Every judge I know that's gone to it leaves really inspired and changed. So I would offer resources and know that judges do really like case law, because we like to be following the law. So whatever you can present in court on even the Nicholson case, if you think there's something lacking in the social worker's approach, all of that is really vital.
And connecting with, again, the attorneys are making those arguments and pushing in court for those things. So if you can connect with the attorney for the parent, for the child, and say, hey, I'm here, let me give you some education, let me support your client in court. Did you know that there's this standard out there? That's going to help move the court's perspective as well. At this point, I just want to thank everyone for their participation, especially Judge Lucero. That was a really wonderful presentation, and I appreciate you taking the time to do that. We're going to leave the room open for another 15 minutes or so, and if you have questions, you can put them in there and we will respond to you. The other way, of course, to get a hold of us is through our 800 line or the email in the link above. So thank you again so much, and at this time we're going to end the presentation, but we'll leave the chat open. If you have additional questions, we can take them and respond to you later. So thank you so much.
Thank you. Bye-bye.